For indigenous peoples, the issue of land is very important. We depend on the land for physical and cultural survival as a people. We have a spiritual, material, and economic relationship with the land. And when it comes to legal issues around land, we in the Americas have been able to build a consistent case law from the Inter-American Court on Human Rights regarding collective ownership rights to the land. And you may wonder, what does it mean? What does Leo mean when he says collective ownership? It simply means that per community must be a collective title. Both the Inter-American Court on Human Rights in the Awastigni case, a case that my office handled before the Inter-American system, stated that indigenous peoples, based on their special relationship to the land, have an ownership as a people of that land, and that state needs to demarcate and title that land, acknowledging that ownership, that is, titling individually per members of the community equals a violation of the collective ownership right of indigenous peoples. And you may wonder, what is that right? It's, if you read the American Convention on Human Rights, Article 21, the right to property, it explains what that right means. But if you go and read the decision from the Inter-American Court on Human Rights in 2001, you will have a full explanation about the legal reasoning why indigenous peoples are collective owners of the land. And we also found similar interpretations of the African Charter on Peoples and Human Rights based on the Indoro case, where apart from finding that lack of titling of land violates property rights of the Indoro community, the African Commission on Human Rights stated that it also violated their right to development as a people. And we are here at the World Bank discussing this issue because we believe that the World Bank needs to provide clarity regarding collective ownership rights of indigenous peoples to their land within their safeguard framework. It will be important for the bank in order to achieve better development results, prevent land conflicts, and guide countries to strengthen their land governance systems. We have learned recently that the World Bank has also embraced the land tenure guidelines, and we have big concerns about that as an organization, as an organization that has represented communities in legal cases. And the reason is this: the idea behind land tenure is a very good one, but the language that is used has implications that are controversial, especially in countries with civil law legal systems. And let me explain a little bit why, before we give the chance to the panelists to make their presentations. In our countries, I'm from Argentina, indigenous peoples own the land based on possession. And you may wonder what possession means. It simply means using the land, behaving the land as you own the land without having a legal title and without acknowledging in someone else's naked property. Well, tenure is exactly the opposite. It means using the land, acknowledging in someone else's naked property. And if we follow the CIO approach blindly and lead countries to have tenure security systems based on the use of tenure, we are simply going to undermine the rights of indigenous peoples to their land based on possession. And no wonder you will find in developing countries, especially in the forest, many indigenous communities that may not have a formal state-issued title, but they do have possession. They have a traditional possession of the land, and based on that, the Inter-American Court and the African Commission on Human Rights recognized collective ownership of that same land.